kerajaan mengambil tindakan untuk memasukkan ISA. Kerajaan mengatakan ini hasil daripada keinginan kerajaan untuk mendemokrasikan Malaysia. And they say the government says that this is a way to have new democracy. I think that is taking away a lot of the credit from the people and the activists, especially the groups like Gerakan Masukkan ISA, the Bar Council, and so many different groups who have been fighting against ISA since the 1960s. So the first thing I think you need to remember in any discussion is that the government shouldn't be taking credit for this. I think the government has come under so much pressure that they could not stand it any longer, and they had to change it. And the point that I'm making is that it's important, even though it was a long-term struggle, so many years, that the people must continually struggle and be very vigilant about these type of things. And if the people didn't struggle, the groups didn't come up and fight the ISA, we wouldn't have come here so far. So that's very important. That's a very important point. Every time when government or government minister says the government is trying to democratize our country, yes, it may be true, but also they must not take away credit from the people that struggle against these bad laws. So I think that is the first thing, that the context to preface the SOSMA discussion. There are at least 8 reasons, terdapat 8 alasan mengapa, walaupun ada beberapa perkara, yang paling penting perkara bahawa di bawah SOSMA, menteri tidak lagi ada kuasa untuk menahan 2 tahun dan 2 tahun selanjutnya. So di bawah Seksyen 8 ISA, menteri ada kuasa untuk menahan, dan di bawah Seksyen 8B, perintah menteri tidak boleh dicabar di mahkamah. But now SOSMA has taken away that power. So the minister has no longer any power to detain anyone. And that is actually the biggest, I think, victory for the people, and also the biggest victory against the ISA. However, yang merisaukan adalah bahawa polis masih ada kuasa mutlak untuk menahan seseorang untuk 28 hari. Dulunya 24 jam, dan mesti dilanjutkan 48 jam, dan sampai 28 hari, and then 60 hari maximum. Now is 28 hari, but the safeguard yang kita telah meminta bagi tahanan oleh polis tidak ada. Safeguardnya adalah supaya tahanan tidak dibuat oleh pihak polis, tetapi tahanan sebenarnya dibuat oleh mahkamah. In all over the world where there is legislation that is similar to this, it is the courts that actually continue the detention of the detainee. It is not the police. So the problem with the ISA 60 hari itu is going to be the same problem under SOSMA, because you can detain, although for 28 days, it is the police discretion. So the same problem will happen, and from the research and from the documentation, tempoh yang paling berbahaya adalah tempoh di bawah tahanan polis. Itu masanya terdapat banyak masalah-masalah berkenaan access to counsel, berkenaan kesiksaan, and forced confessions. So that issue is also now main issue which we need to fight against SOSMA. The second alasan yang penting yang kita mesti cuba ingatkan adalah bahawa SOSMA bukannya satu undang-undang biasa seperti ISA. ISA telah dibuat di bawah artikel 149 Perlembagaan Persekutuan pada masa itu untuk menentang komunis yang violent. Tetapi hari ini di bawah SOSMA juga undang-undang di bawah satu artikel 149 juga telah dibuat. So SOSMA, while we are in peace, there's no communist fighting in our borders, is still being enacted under our emergency law. So article 149 gives special powers to the government to enact emergency law. In effect, SOSMA is an emergency provision. And when government says that we want to make this country more democratized, actually it's not true, because they've just passed a law in 2012 that actually is an emergency legislation. So some rights under the constitution, like your right to life, your right to liberty, your right to access to counsel, the right to the courts, is accepted, meaning it's taken away if the law is made under Article 149. So SOSMA is an Article 149 law, which is exactly the same as the ISA, which was made under Article 149 as well. So this is very concerning because, and very disconcerting, because from the news reports that I've not checked Hansard, but the government has not said why they have to enact Article 149. They said that there's terrorism, sabotage, but they didn't say that but they must, for us, under the Constitution, in Article 149, you must show or give evidence, or at least say who this substantial body of persons are that is a threat to security. That is the special preamble to Article 149. You can only use Article 149 if you can show who are these substantial body of persons who are at our borders, within or outside Malaysia, who are threatening Malaysian security. Until now, the government has not stated or said who these substantial body of persons are who are intending to use violent means to overthrow the government. So again, we object to the use of Article 149 because it creates another impression, or continuing impression, that Malaysia is still under an emergency. And it is no different from the ISA in that sense. The third issue that we need to be quite concerned about is that the government and the Attorney General's chambers has the right to withhold what they call sensitive information. So if somebody is charged in court under SOSMA, the government and the public prosecutor is entitled to not give sensitive information to the accused. And if they're not entitled to give the sensitive information to the accused would not be able to defend himself. So the lawyer cannot see it, only the court can see it. And this sensitive information to us amounts to conducting trials almost in secret. So you have certain part of the information and evidence which they are supposed to give us as accused lawyer, but they will not give. How do you expect the accused person to be able to defend himself? And this goes back to even, I think, very similar to how it was done last time under the emergency laws, where you have trials and witnesses are hooded, where their eyes are, their face is closed except for their eyes. That happened a long time ago during the emergency because they didn't want to have the informer's identity coming out in the open. So there are a lot of these special provisions which amounts to secret trials under SOSMA. And this is something that I think revives the emergency type of trials long time ago. And this is something that people who are not so technical or have not read the whole bill because it's very long, do not realize. So there's a lot of provision there where if you are accused of a security offence, you stand to face a trial which is in fact a trial in secret. And there are provisions as well for the trial to be held in camera. So the court can actually, on the application of the Attorney General, hold some trials in camera. In camera meaning it's not a public trial. So now criminal cases, you can hear cases publicly, you can go to court and you can watch. But there are some trials under SOSMA where it can be held in secret. And that's again very disconcerting because we do not know the criteria, and knowing how the government and the public prosecutor has acted many times, we are very concerned about how, if somebody is charged, whether he will be properly defended in court or not. And then on the other hand, the burden on the accused is that if the accused wants to review sensitive information to defend himself, he must give notice to the public prosecutor in advance. 2 days in advance. So you have a provision of law which is so unfair now. Not only can the public prosecutor stop sensitive information from coming to court, if you want to give sensitive information, if you are the accused person, you must give 2 days advance notice what the sensitive information is. And then the public prosecutor and the court will decide whether the sensitive information can come out in court or not. So the way that it's been done is very heavily against the accused person. And this is not something new in the sense that we have always said in criminal trials in Malaysia, lawyers who defend criminals actually, or accused persons who accused of a crime, are actually in a very huge handicap, because the criminal trials in Malaysia are done by ambush. In other countries, in England, in Canada, after the Guildford 4, after the IRA type of bombings where some people were wrongly convicted, the governments there had amended the law to say there must be full disclosure of your prosecution's case to the defense before you go for trial. So including evidence which is not going to be used, including evidence which is favourable to the accused, you must give. So everybody goes to court on a fair plane. But here in Malaysia, every day lawyers fight in court, fight criminal cases in court where the balance is tilted against them, because there is no what we call pre-trial disclosure. So lawyers who are defending accused persons in court do not actually know what the case is about until the first day they step in court. In fact, that is what's happening. So on top of that, you have this type of problems about the sensitive information and your secret trials under the SOSMA provisions. Then the fifth point also is about electronic monitoring. I think the government has introduced through this bill for the first time electronic monitoring. Means if you are suspected of an offence, even though you have not been convicted, the court can be asked to fix an electronic monitoring device on your leg or your hand. I don't know how it works, where the police can actually track wherever you go. Again, we think that is a fundamental breach of rights, because you should only do this as a form of punishment after somebody is convicted. You shouldn't do this when somebody has not been convicted. Then I think the other provisions which we are very concerned about is the fact that you are not, if you are detained currently under the ISA, you actually have your detentions continued under SOSMA, although the ISA has been repealed. And that's why I think some of the current detainees in Kampung Ting are going on a hunger strike, because they know that the ISA has been repealed, but they are still being detained under what this new law is, the SOSMA. Bearing in mind that it's very unfair, because SOSMA does not have the powers for the minister to continue the detention for 2 years. So the ISA has, you have the power for 2 years, your detention order is made under that. SOSMA, the minister has no power to detain under 2 years, yet the orders made against you under the ISA for 2 years continues under an act where the minister has no such power. So it doesn't gel, it doesn't make sense. If SOSMA has 2 years, the minister's power to make those kind of detention orders, then at least it gels. But now it's a very funny situation where there's no longer this power, yet the old order under the ISA continues. So we are planning with the team, I think from GMI and LFL, to visit them, I think on Thursday at 10 o'clock, and then try and take instructions from them and speak to them, and then see how we can proceed from there. I think one of the legal challenges that can be taken is whether these detention orders are still valid under SOSMA, because these detention orders were made under a law that has been repealed. Number two, whether Parliament, when passing the law, had sufficient material before it to decide whether there is a real threat to the national security of Malaysia, who are these substantial body of persons who are threatening Malaysia, and whether that evidence was laid by government. And then number three, of course, the abuse and during detention by the police and the special branch And I think even in prison, we should investigate all this and try and see whether these are grounds to get them released. So there are a few legal challenges which we can think about, but we will have to wait until Thursday to speak to them to confirm certain facts and what they themselves want to do.
Saya rasa itulah sebenarnya the crux of the matter. Itulah sebenarnya inti partinya pun. Kita boleh cerita tentang kejayaan, tentang apa yang berlaku sebelumnya, tapi kalau kita lihat sebenarnya that is what is facing us now. Sekarang ini kita berdepan dengan sesuatu yang kita ramai orang anggap sebagai satu kejayaan, tapi adakah dia benar-benar satu kejayaan? Before that tapi untuk menjawab soalan Saudara Syed tadi itu, bagi kita JMI memang kita menganggap mula-mula apabila kita dengar bahawa ISA ni akan dimasukkan, kita memang menganggap itu sebagai satu kejayaan. Cumanya kejayaan itu memang kita dah sebut juga daripada awal, dia bukan macam Saudara Edmund sebut tadi, bukan kerana JMI sahaja, but of course not because of the government, tapi juga bukan kerana JMI only, but it is due to the effort, desakan, pressure yang dibuat oleh ramai orang, a lot of people. Kita cuma rancang sikit sana sikit, kita strategi sikit, bincang-bincang dengan Edmund macam mana nak buat kan, lawyer apa semua, betul kita execute together dengan the people. And I think that is why it actually is a very strong force, strong pressure given to the government. They don't have a choice. Kita nak kena pressure sehingga mereka tidak ada pilihan lain. Kalau kita tengok sedikit sebanyak, itulah juga efek kesan dari Brexit. Kalau boleh saya sentuh sikit. Jadi kalau kita tengok sebenarnya ISA ni dia memang dia terlalu lama lah. Dia dah menghantui rakyat selama 52 tahun, sejak tahun 1960 lagi. Macam hantu raya. Dan dia juga telah pun sebenarnya menyebabkan demokrasi negara kita ini seolah-olah jalan tetapi terbenam sekat-sekat. Kalau boleh saya give an analogy, dia seperti air sungai. Air sungai ini dia sebenarnya dia ada satu ruang yang luas untuk berjalan, tetapi dia ada banyak batu, dan batu-batu ini telah menyekat laluan air sungai ini. So along this one kita telah mengalihkan batu-batu ini, dan batu-batu ini sebenarnya makin lama makin terhakis. Makin lama makin terhakis. So what we did was kita accelerate, kita cepatkan, kita expedite, kita deraskan air itu supaya bukan sahaja batu-batu itu terhakis tetapi dapat dialihkan keseluruhannya. That is what we did. Cuma pada masa yang sama kita kena yakinlah juga bahawa without ISA negara kita tidak akan berada dalam keadaan huru-hara ataupun kocak-kacir, hancur seperti mana yang cuba dibayangkan oleh mereka. And I think this is also the premise made for SOSMA juga. Sebab itu dia diletakkan di bawah perkara 149, preventive maknanya preventive measures. Dan I think one of the sama juga premis seperti mana ISA, iaitu dia boleh seseorang itu boleh ditahan atas dasar syak sahaja, reason to believe. That is still within what is in ISA, it is still retained still dalam SOSMA. Sama. And that is also satu masalah yang besar sebenarnya. Hanya kerana ada kepercayaan sahaja. Dan kalau dulu ISA hanya kerana ada kepercayaan bahawa seseorang itu boleh sama ada akan, sedang atau telah. So powerful is the reason to believe ni. Jadi oleh kerana itu kalau kita tengok sebenarnya kita ada banyak lagi undang-undang yang lain yang begitu banyak. Dan kita juga sepatutnya ada intelligence yang sepatutnya smart. Tapi seolah-olah dengan ada ISA kita tidak ada orang yang intelligent yang smart, yang banyak yang tak smart sekarang ni, tak lain. Yang buat kerja-kerja yang sebenarnya tidak smart, yang mudah, yang convenient for them, rather than untuk mempertahankan benar-benar keselamatan negara. And we have also this institution of security like the police, custom, immigration. Semua ni ada. Di samping ISA, we have all this at the same time. Not to mention the penal code, kanun kesiksaan. Yang dalam tu pun sebenarnya ada banyak tambahan-tambahan perkara yang boleh digunakan untuk isu-isu keganasan. Jadi kita lihat ISA ini sebagai satu igawan buruk kepada tahanan, bekas tahanan, keluarga. Tapi sebenarnya what makes it important and also very important here, relevant here, is that it was also a nightmare for the government. It was also a nightmare for the government. Ya, dia orang tak boleh senang duduk. Pak Lah kena ambush, dulu Mahathir kena ambush. Ya, Najib ni belum sempat kita ambush, dia dah counter dulu. Tapi now kita akan ambush juga lah kalau SOSMA ni, ya, something which is going to be there. Ya, mungkin juga perkara itu perlu dilakukan. So it is nightmare for the government, yeah, because it actually brought bad image. Ia memberi satu image buruk kepada kerajaan, bukan sahaja dalam negara tetapi di luar negara. Ya, dari segi isu hak asasi, hak kebebasan, kezaliman, salah guna kuasa, torture, everything was brought to the front. Semua kita explore, kita keluarkan, kita exposekan. Ya, jadi perkara-perkara itu sebenarnya memang menjadi masalah bagi mereka. So saya balik pada apa yang disebut asal tadi. They don't have a choice. Mereka tidak ada pilihan lain. Cumanya mereka ada pilihan ialah untuk nak sebut kenapa mereka masuk ISA. And they choose these words very carefully. They never mention that it is because of the pressure by the people, it's because of the pressure by the groups, it is because of the torture. They never mention these things. Apa yang disebut cuma dia kata adalah untuk membuka ruang demokrasi kepada rakyat. Ya, ada sikit saja kalau ada pun disebut ialah untuk mengikut kehendak rakyat. Tapi dia tak sebut apa maksud dengan kehendak itu. Ya, jadi they are very careful about this because they know if they can mention these real things, definitely esok lusa dia akan tumbang. Okay, that is the effect. Jadi apa yang kita buat, saya rasa JMI cuma kita ni mempercepatkan. We accelerated the transformation, quote unquote. Yeah? But again, pemasuhan ini adalah satu pemasuhan yang sangat signifikan. Yeah, we still acknowledge that. Sebab itu bila sebut kata ISA itu telah dimasukkan, yang pertama yang saya sebutkan kepada reporter when they call me the night before, actually the night before the announcement tu, reporter sudah call saya, dia tanya apa pandangan Tuan Syed sekiranya ISA dimasukkan esok. Sebab saya dengar-dengar ada ura-ura bahawa Perdana Menteri akan buat pengumuman esok ISA akan dimasukkan. Jadi my first words were, yes, we welcome it, but at the same time based on past experience, based on our engagement dengan government and also the Ministry of Home Affairs, we have to be very cautious about why this is being done and whether there are any other replacement act is actually being done. And true enough, that is what happened. Ya? Jadi signifikannya saya rasa ialah kerana dia telah memberikan kita satu ruang yang besar untuk kempen. It has given us a lot of room untuk kita kempen, kita buat exposure, tapi pada masa yang sama banyak pengorbanan, sacrifices were made. I did along the way. A lot of people were detained, bukan mungkin bawa ISA tapi juga bawa undang-undang yang lain. Ya, ada yang masuk keluar lokap dan sebagainya. Saya masuk cuma beberapa jam saja. Ada sekali itulah. Okey, jadi tapi saya rasa ini semua adalah penting sebab dia menunjukkan bahawa sebenarnya memang rakyat bersungguh-sungguh dan rakyat berani untuk menegakkan yang hak dan juga untuk mencegah yang batil dan membukakan pemikiran kita. Jadi kalau boleh saya sentuh sedikit tentang SOSMA ni juga. Saya rasa saudara telah sebutkan beberapa perkara tadi, tapi saya rasa yang asas sekali kepada SOSMA ni adalah tafsiran, the definition of kesalahan keselamatan. Yeah? Security offence. It is still arbitrary and wide open. What is a security offence? What is it? It's never been defined. Currently they are saying that they will akan amend, and they have amended probably the penal code to actually define what is the kesalahan keselamatan. Tapi saya rasa dia ni akan balik kepada asal, which is talking about subversi, mengancam keselamatan negara, which is still very broad. Yeah? And even if they mention dalam SOSMA dia sudah sebut, dia kata bahawa tidak ada penahanan yang dibuat berdasarkan kefahaman politik seseorang. Tapi let's look at it very cautiously here lah. Itu pun atas dasar kefahaman politik. Tapi kalau dilakukan tu sebagai satu tindakan yang boleh mengancam keselamatan, kesalahan keselamatan, walaupun dia sebagai seorang ahli politik, dia boleh jatuh sebagai satu kesalahan di bawah SOSMA. Okay? So, bagi kita sebenarnya any detention is political. Dulu bawah ISA pun kita telah acknowledge that any detention sebenarnya bawah ISA was political. Ya? Contohnya macam Bukhari Tahir dulu, if you recall, masa tu dia ditahan kerana isu pembekal komponen nuklear. Tapi yang sebenarnya lebih relevan ataupun yang lebih sebenarnya adalah kerana dia berkaitan dengan SCOMI yang ada kaitan dengan anak kepada Perdana Menteri pada masa itu, iaitu Tun Abdullah Badawi. Isn't that political? Kemudian penahanan JI, ya, lepas September 11, ya, ramai yang ditahan, beratus-ratus orang yang ditahan kerana untuk melawan keganasan. Tapi sebenarnya adalah untuk menjadikan mereka ini sebagai scapegoat, kambing hitam, untuk menunjukkan bahawa Malaysia berjaya untuk menangani keganasan dan oleh kerana itu menyokong dasar Amerika Syarikat. Okay, they will make scapegoats, hundreds of them. It was never proven that they were involved with any criminal offences ataupun termasuklah tentang keganasan. Kalau ada proof, masuk dalam mahkamah dan find them guilty dan kemudian hukum mereka. Tapi itu tidak berlaku. Okay, so it's all political when it comes to tafsiran kesalahan keselamatan yang terlalu luas dan terlalu arbitrary. Okay. Dan satu lagi ialah banyak kali disebut tentang saya rasa yang lebih relevannya adalah berhubung dengan penahanan ni. Penahanan tanpa bicara. Okay? Saya masih ingat lagi, saya baca satu statement oleh Hishamuddin Hussein sebagai menyokong bos dia, ya, bila bos dia buat bacaan di Dewan Rakyat membentangkan ram undang-undang SOSMA ini pada ketika itu, Najib telah sebut bahawa ini akan menafikan ataupun membuang segala persepsi negatif terhadap kerajaan yang menahan orang tanpa bicara. Kedua, dia kata kuasa kepada menteri juga dihapuskan. Okey. So, kalau kita tengok dari segi penahanan tanpa bicara ini, kita dari segi JMI kita konsisten daripada dulu bahawa kita sebut seseorang tidak boleh ditahan tanpa bicara walaupun satu hari. Ya. And of course, kalau tahan remand itu bukan tahan tanpa bicara. Okay. That is a remand process, that is a due process of law. Tapi dalam kes SOSMA ini, ya, mereka kata sekarang kita dah kurangkan penahanan oleh polis dari 60 hari kepada 28 hari. Tapi this 28 days, 28 hari, bukankah dia still tahan tanpa bicara? Dia masih lagi tahan tanpa bicara. Maknanya dalam tempoh ini sebenarnya polis boleh melakukan apa-apa sahaja kepada tahanan. Ya, dan dia tidak perlu ambil masa lama sebenarnya. 5 hari, 4 hari pun sudah cukup. Ya, kalau dalam kes ni, okey, mungkin 48 jam, they don't have any choice, they have to bagi akses kepada konsul. Ya, dia kena bagi akses kepada peguam. Tapi lepas 48 jam sampai 28 hari, it's up to the police. Ya, it's up to the police. Dia nak buat apa pun boleh. And there is no court. Tak ada proses undang-undang, tak ada proses mahkamah dalam tempoh tersebut. Okey, still. So walaupun kurang, tapi kita tidak boleh lepaskan begitu sahaja. Tempoh yang pendek ini tetap ada berlaku sebenarnya penahanan tanpa bicara. Okay. And then secondly, I think even to mention kuasa menteri dalam negeri. Yes, as already mentioned by Edmund, sebenarnya macam seolah-olah kuasa menteri dalam negeri itu tidak ada. Tapi kalau kita lihat, selepas katakan 28 hari dan pihak polis ingin mendakwa, ya, seseorang yang ditahan di bawah SOSMA ini masuk mahkamah selepas 28 hari, kemudian mahkamah membebaskan dia. Mahkamah membebaskan dia, tapi pendakwa raya boleh memohon rayuan secara lisan, ya, verbal appeal without having to provide any other evidence for the detainee to be further detained until the appeal process ends. And the court, correct me if I'm wrong, the court has no obligation to deny the prosecutor that appeal. Ya. Tapi kalau kita tengok pendakwa raya ni, dia answerable kepada siapa sebenarnya? Ya. Dia answerable kepada, accountable, responsible kepada, dalam kes ini, Menteri Dalam Negeri. It is still within the powers jurisdiction of the Minister of Home Affairs, not directly but indirectly. Okay, so maknanya bagi saya, walaupun kita nampak macam seolah-olah Menteri Dalam Negeri tak ada power, tapi the powers are still there. So the law ni is actually is more dangerous than ISA, because pada orang ramai, orang akan nampak 60 hari kurang 28 hari, ada proses mahkamah, ya, kemudian ada mahkamah, kemudian ada ruang ataupun akses kepada lawyer, dan kemudian mereka yang dibebaskan itu bebas sebenarnya, tapi cuma tambah satu ada electronic monitoring device saja, itu sikit saja. Ya. So kata macam ni sebenarnya dia nampak seolah-olahnya baik, tetapi sebenarnya di bawah itu adalah satu perkara yang juga jahat. Ya. Dan this time orang masuk dalam SOSMA, kalau boleh saya tambah sedikit lagi, ialah dia sudah ada peruntukan-peruntukan tambahan tentang interception of communication. Dulu dalam ISA tidak ada semua ni. So they can always intercept. The police have all the right to intercept communication, handphone communication. They can pasang bugs and all that secara mengikut undang-undang. It is within the law. They can actually do that within the law. Okay, so there's no personal liberty there, privacy apa semua ni. Memang maknanya mudah untuk dirampas, dan oleh kerana itu lebih berbahaya. Okay, I believe probably this is taken back from the UK ataupun from the US punya Terrorism Act. However, there are memang ada issues ataupun problems regarding this law. Okay, so saya rasa sebagai GMI lah, sama ada kita dimasukkan ataupun tidak, kita belum selesai lagi tugas. As mentioned by Edmund, there is a provision under the new law, ada SOSMA perkara 32/2 ini, untuk siapa-siapa sahaja yang ditahan di bawah ISA, perintah tahanan itu akan berterusan sehingga tamat tempohnya, ataupun dibatalkan oleh Menteri Dalam Negeri. So actually ada option di situ sebenarnya. Tapi itulah macam kata Edmund, agak pelik. Sebab dalam SOSMA, Menteri Dalam Negeri tidak ada kuasa. Tapi macam mana boleh ada kuasa untuk menahan seseorang itu sehingga tamat tempoh dia? So sangat-sangat pelik, sangat-sangat aneh. Tapi itulah yang berlaku.
Bebaskan tahanan.
Bebaskan tahanan.
Bebaskan tahanan. Bebaskan tahanan.
Bebaskan tahanan. Mansuh, mansuh. Mansuh, mansuh. Mansuh ISA. Mansuh ISA.
Sabtu ini 30 Jun kita akan ada candlelight vigil depan pintu utama Bukit Aman jam 8 malam. Kita jemput